welcome everybody who could join us today for the third lecture of the third series on data protection. It is an election tracking again and what can be done about it. And our speaker is Stefano Rossetti, who is a qualified lawyer on media law and data protection. He is working in the European Center for Digital Rights. The acronym means none of your business. That's very nice. Many of our colleagues knew it, but they didn't know what it means. So Stefano focuses on strategic litigation on unauthorized online tracking, dark patterns and workplace surveillance. This is very useful. He wrote several publications and he's responsible for the GDPR hub at noneofyourbusiness.eu, which is a free open source legal database for users and professionals. So we look forward, I mute myself now, and we look forward to listen to you, Stefano. At the end, there will be time for questions and comments, so don't go away. And tomorrow we shall have Stefano with us again, same place on Zoom. Thank you. Stefano.
Hi, everyone. Thank you, Maria, for your invitation at the CERN and for everyone for listening to this presentation, which I hope is going to be useful and interesting for all of you. So as Maria just said, I'm going to, today we're going to talk of online tracking problems and legal remedies, but I know already that over the last two lessons, the problems have been already underlined and explained quite in detail. So I decided to focus a little bit on the legal remedies, which is also the focus that we have at NOIB. So like just to give you like a quick overview of what we're going to discuss. I'm going to do a short presentation of NOIB, what it is, what we do. However, Maria already disclose the meaning of the acronym, none of your business. Then we are going to, but very quickly, I'm not going to make it boring, hopefully, like going through the main principles and legal underlying legal ideas in the GDPR and other applicable legislations in this field, because it's not only GDPR. There's already something which is somehow old and something coming, and we are yet not sure if what it's coming new is already old, but we're going to discuss that very quickly. And then finally, well, the core of the presentation will be on the enforcement projects that NOIB is undertaking at the moment, and mostly on those projects where I was mostly involved. Online tracking and trackers, and how to stop the trackers or possibly to reduce online tracking by reducing the amount of trackers in the system. And then I will quickly mention the GDPR Hub, which is, as Maria said, like our free legal database, collecting information and decisions from across Europe, from DPAs and courts, all in English, all available for the public in case you guys want to take a look. So first of all, what NOIB is. None of your business, or European Center of Digital Rights. We are based in Vienna. We are a not-for-profit organization, independent. We are funded, like 90% of our funding comes from members, but also from some foundations and like specific projects that we run with other organizations that want to engage us in terms of like as they are legal counselors. It was created by Max Schrems, who is an Austrian lawyer and activist who first brought this first action against Facebook on international transfers. It's the famous Schrems 1 and 2 case, basically following Snowden revelations about NSA and in general the US government running bulk surveillance programs, also on data coming from Europe, personal data coming from Europe, then Max basically brought this to court and had this the mechanism by which data could be transferred to the US freely, annulled by the Court of Justice for the first time. And then a second and probably a third one is coming. So we will see. So we're based in Vienna. When I arrived, we were more or less 5 or 6 people. Now we are 21 or 22. So the team is getting bigger and bigger. We recently hired two new lawyers, one from Slovenia and the other one from the Netherlands. And we are essentially the core of the team is made by lawyers. Because the core of our action is legal enforcement, really. But obviously, like around it, we have like PR specialists, communication specialists, technologists, and all the people that really make it possible. And there's a lot going on. The more I live and work within this organization, I realize that we really need a lot of knowledge and different knowledge, specific knowledge. To run this in an effective manner that makes sense to the donations that we receive. Yeah, I just said I think this is a little bit outdated because probably now we are around 4,000 supporters, and we receive like a fair amount of donations, and then, as I said, we receive also additional foundations by funding and granting by some other organizations when our paths cross somehow. Out of the structural part, the idea around NOIB, behind NOIB, is to kind of feel a structural issue in the GDPR and in general in the digital right field, especially when it comes to the private sector privacy enforcement. The idea that under the GDPR is the second generation law that we have in Europe. Before it, there was a directive also regulating the matter, but it was implemented in different ways. And one of the major failures of this directive, which was okay, it worked. It established the first framework around which European countries could discuss. But the thing was, it started with the idea that data subjects, as in particular, are entitled, have a right to control their data. But then, like in the practical application of it, there was some problem. We will be mentioning that because they have not disappeared with the GDPR. It got better, slightly better, but still there are some issues, considerable issues. So the idea is that to basically use the GDPR to reduce the gap between privacy in theory and privacy in practice. So, and obviously we are definitely more on the side of the users and the citizens. We are not, although I just mentioned that one of our biggest cases originated from like a government surveillance case, the US one, but we actually focus on like private companies enforcement. So we kind of the government surveillance in that case was used to stop the transfer from Europe to the US because there was in the background there were these surveillance programs. We also raise or try to raise public awareness around specific topics. One example of this is also in these slides. For example, a few years ago, we studied different privacy policies from different streaming companies. And in that case, we kind of analyzed what was good and what was not so good in these privacy policies, put them in a nice and easy way in terms of like green lights, red lights, orange when things are kind of improvable. And obviously we provide legal assistance to our members. This is the core of it. Probably we receive communications from our members, but also non-members. And like in accordance with our resources, which are unfortunately limited, we do a selection, and we whenever we can, we bring a case to court, or we send a letter to the controllers so that something can be fixed. So there's from time to time we receive very interesting tips, and then we base our enforcement projects on this. I would say that most of our enforcement projects we're gonna discuss later are inspired by our members. All right, so this is it. Just to give you a quick overview of the applicable laws in this field. Well, first of all, the GDPR, General Data Protection Regulation, it's in force. Then we have the e-privacy directive, originally brought in 2002, amended in 2009. The main difference between the GDPR, which is a regulation, and a directive is basically that the GDPR applies directly within each member state, while a directive needs an implementation, a transposition by the member states. So like with the parliament law, to kind of put that in the legal order. This e-privacy directive is important, and I'm mentioning it because part of our projects and also of our online life is regulated by specifically Article 5.3, this e-privacy directive, also known as the cookie law. Whenever you are asked to provide a consent for cookies, let's say, or installing, having your computer or device in general installed with some sort of tracker, you are supposed to provide a consent, and that comes from the e-privacy directive. So it kind of interplays a bit with the GDPR. Then there is an upcoming AI Act. People are talking a lot about it following the AI development. Obviously, now we are all talking about ChatGPT, but the AI is a much wider, as you well know, definitely better than me, wider topic. And there is a proposal at the moment. The EU institutions are kind of negotiating this draft. I was kind of making a little joke before because there is already some criticism around this new law, because it seems to be already a bit old in terms of not really addressing the real issues. So that's why the different actors are trying to discuss the matter. And also a very important tool, which I think it's another directive, so it needs implementation. It's the so-called class action collective redress directive. It's a tool by which consumers could finally organize, gather up, and bring cases to court in a sort of organized, structural fashion, and that obviously helps because it's more effective. We will see that one of the main problems in the directive before was that it basically conferred individual rights. But then you have structural problems in front of you, and as a citizen, with generally limited financial resources, time, and knowledge to address certain issues, you really need sometimes to gather up with other people, or maybe to kind of call in people like Noe, so that things can be faced in a more organized way. So these are the main tools we have at the moment: GDPR, e-privacy directive, AI Act forthcoming, and then the class action directive, which is already some member states have already implemented in their legal order. Now, the GDPR, very quickly, it's a regulation. So we said it's directly applicable in all member states. And the idea behind, I think it's well explained in recital 11. It's the effective protection of personal data throughout the union, and by strengthening and setting out in detail the rights of the data subject and obligations for the controllers. So you have two main souls in the GDPR. The first one is principles and obligations that controllers must adhere to, regardless of any action brought by data subjects. And then you have another kind of soul, which is more on the level of the individual rights and the subjective rights of people. And the idea is that, whenever you think something is going awry, or just want to know more about, what's going on with your data about, like in a company, you have tools, and we will just quickly do a rundown to kind of check what's happening, and then possibly object, reduce, have data erased or corrected. So generally, the idea is to control the processing by principles, by specific provisions. So the main principles are transparency, lawfulness, fairness, proportionality, security. It means that the processing must be explained, must be transparent, easy to understand, must be lawful. So there must be like a legal reason, legal justification to it. So consent, for example, contract, legitimate interests, these are all examples of legal basis, but also, I don't know, a legal obligation. Sometimes a controller must hand over some data because the state so requires. So that is another example, but there must be an underlying legal reason for processing personal data. Otherwise, it's prohibited. So that's a little bit the thing, processing is an exception and only takes place when it's justified. Otherwise, you cannot. And then proportionality, only the data that are required to perform in general, to perform a certain task are allowed, otherwise not. And security, finally. So, the data breach is a big thing with with the open society, with the technological development. And controllers must be up to date, keep up with the technological development, and only use tools that ensure security. So all these principles are in Article 5, and then we have specific provisions that somehow transform these principles in reality and stuff we can see in our everyday life. And for example, privacy policies. They are an example of transparency, and they're regulated in Article 13. So whenever you go on a website and you have a privacy policy that comes, because that document should explain you the processing. The document should also tell you like which legal basis have been used. Then other specific provisions are data protection by design and by default. It means that whenever we start data processing, these at the very moment we start designing this processing, we need to implement these principles. So it's and tools that enable us as controllers to provide information, being transparent, but also to kind of see if something is being done under the appropriate legal basis or not, if it's secure or not. So like faced by, I don't know, a decision between a software that we know very little of and another one which is, I don't know, being certified and we know how it works, it's safe, it's been, run by a reliable company, then we should definitely go for the second option. And yeah, that's more or less the framework around the obligations. And then we have data subject rights, which is mostly what we focus on at NOIB. I mean, we also sometimes have, like some complaints or some actions that focus on the obligations. But generally, because we are siding with the citizens, we generally work with them, and therefore the main violation is always a breach of their rights. The rights are we can quickly go there. Access rights, deletion, rectification, right not to be subject to algorithmic decisions. That's more or less it. Just a couple of points on lawfulness. Okay, it's in Article 5. The main legal grounds, as I said, are consent, contract, legitimate interest, legal obligation, a few others. Consent, this is important for what we're going to say. Sorry for the little, legal introduction, but consent must be freely given, specific, informed, and unambiguous. So these are the elements. if they are all there, then the consent is valid. If even one of them is not there, then that consent is not valid, and therefore the processing is not lawful anymore and is in breach of a GDPR obligation. When it comes to contract, it's another legal basis. It's important to understand that the processing based on contract must be, or probably the performance of the contract must be necessary for the processing must be necessary for the performance of the contract. Typical examples are, the hotel reservation. You go on Airbnb, they need to know your name and surname to kind of perform the booking, right? But if they were to ask you or otherwise get information about you that is not necessary for the execution of the booking contract, then we have a problem, because that data is not minimized, as we said, another principle, right? Same stuff with the e-commerce purchases. In that case, like you may want to provide your home address because you want to get the goods at your place, but definitely an e-commerce should not be interested in your political affiliation or what you think about God or whatever philosophical view you may have. Like it's not relevant for the execution of that contract. And then finally, another important legal basis are legitimate interests. So when a company, for example, says like, okay, I want to control my employees because I want to check on their performance, let's say, and I want to make sure they're not stealing stuff from my warehouses, right? There is an interest for the company to do so, because employment law itself allows for that sort of evaluation. But at the same time, it's all based on a balancing of interests. So the company has legitimate interests, but at the same time, as a worker, as an employee, I also have interests. I also have freedoms. I also have rights, and I need to be protected. Let's say if you put, and this is a very trivial example, but that's, I think, explain the logic. If you put a camera at the entrance of a toilet to check how long an employee is using this service, that is probably interfering with some very important fundamental rights of the person. The person may be sick, they maybe take time for some medications or whatever. So this is like legitimate interests allow for processing without data subject consent, but only when the balance of interest between the company, the controller, and ones of the data subjects, are on the same page or prevailed. So the controller's interests prevail over the ones of the data subject. Transparency, we have already said enough about it. For what interests us more is probably the reference to the privacy policies. This document provides information on the processing in general. Then it tells you, like, it should tell you in very clear language. So, like, what legal grounds have been used, the categories of data required, for example, recipients or categories of recipients, sources. There is a common misunderstanding in which generally privacy policies are not very descriptive, and controllers, the industry, claim that this is not possible to be very specific because it would take too long. It would take too long to describe a very complex processing in simple words. It is true to a certain extent, but that doesn't justify sloppiness or the intentional use. So whenever you say, for example, you read in a privacy policies a lot of vague terminology, let's say when they use such as or potentially or we may send your data here and there, these are all elements that somehow should trigger your and our suspicion towards the document, because we actually want to know what's happening, and seldomly that happens. And an example to it, as I was mentioning before, is this little work that we have done on the main streaming services. and their privacy policies. So, the main elements are here in the first column. These are the elements that a privacy policy should convey. The name and contact details of the controller, data protection officer, if available, purposes of the processing, legal basis, the legitimate interest. We just mentioned it. If you're using my data for your legitimate interest, I want to know why, and especially like what's the balancing of interest about. The link between purposes, legal basis, and categories of personal data. The example is the booking that we've done on Airbnb, or the purchase, right? So I want to know like what you need for the purchase is my name, surname, home address, probably a phone number. But if you are also looking for or collecting my sexual orientation for that purchase, that doesn't add up, right? So and this is a little bit the exercise that we have done. And so if you the green light is obviously it's okay, and then the red one is like well, no, not really, and then the orange one is kind of dubious. And yeah, you can find this on our website. Also, you can use this kind of tool to check whether the privacy policy you are reading is complete or not, or in general compliant with the GDPR. Going to the tools that we have to protect ourselves. The underlying idea is that we have this right to control our personal data. What's happening with our personal data? The main right that we have is in Article 15, really, which is the right to access information, to access our personal data, and it's been defined as the keystone of the entire European data protection framework. This right, and rightfully so. You have a right that kind of give you the right to, a clear explanation, a tailored explanation of what's going on with your data. And you need that if you want to then use other rights. It has two main elements to it, the right to access. The first one is the information. So we are entitled to receive like a clear, easy to understand, tailored to our specific case information about, I don't know, purposes, categories, recipients, retention period, and logic involved in all algorithmic decision making, for example. This is kind of like some of you may ask themselves, like, but this is the same information we got in the privacy policy. And the answer is yes and no. It's just what changes is the detail that you are, the level of detail you are entitled to get under the access request, following an access request. So you can know really what's going on with your data and not in general with the data processing. And then you also have a right to obtain a copy of all data undergoing processing. So, and that includes cookies, profiles that have been created about us, even like the smallest online actions, because this is something companies are actually tracking. I know that we've been discussing this stuff in the latest lessons. For example, where I click, if I hesitate on a link or not, if I scroll down and the way I do it, if I'm hesitant, all these elements are collected most of the times, and these are personal data. They refer to us, and in theory, they should be included in this copy, which should also be explained. Now, once you get a copy and once you get a tailored information about the data processing, then you can do different stuff. You can, let's say, go to court because you think something is unlawful. You can claim damages, but you can also further interact with the data with the controller, and you have your data rectified. Meaning under Article 16, the right to rectification, you have a right to correct incorrect information or to complete incomplete information. The example is for, I don't know, some was like an homonymia, let's say. Some of us could be. There's an article on a newspaper about Stefano Rossetti being involved in a theft, but it's another person, and therefore, I have a right to make that point, and the newspaper should put like an update to complete that information or to correct it somehow. Then we have a right to erasure. If the processing is unlawful or it's not justified, there is no legal basis, or it's excessive, then I could have the data deleted. And there is also like a sort of online word transposition of the right to erasure, because generally our data is shared with hundreds of different actors, and sometimes we want to be really forgotten, have our data removed not only by the controller we are first in touch, but also with by other recipients of our data. And so like the right to be forgotten basically puts an obligation on the controller to notify our erasure request to further recipients so that they can take all the actions needed. Right to object to processing in case, let's say, I think the camera put just next to the toilet is excessive and not really covered by the legitimate interests of the of the controller, then I can object to that processing and possibly have that camera removed. And finally, the right not to be subject to automated decision making, which is the problem of algorithmic decisions and also AI decisions. We will see there is these problems are popping up more and more and are becoming really important. ADM, automated decision making, is being used for several purposes. It's not only deciding whether, I don't know, you can access like a certain room, but also, let's say, it's done for job selection, it's done for background checks, it's done for whether, we will be discussing this tomorrow, but, whether a publication by a researcher should be, put at the top of the list or not. So all these elements are somehow and more frequently run by these decisions run by algorithmic or otherwise artificial intelligence technologies. So this is also, we have a right to object to that sort of decision-making process. I know that you have gone through the ad tech system in the previous classes, and so I'd just like to make an example. So let's take this GDPR rights, and in practice, it is all simple, very clear. You send a request to your controller. Your request must be facilitated. It means that the controller must do whatever is possible, must act proactively to have your right respected, and then you get a response from the controller. In general, the response must be clear, concise, tailored, transparent. It must be timely. In general, the deadline to respond to a request is 1 month, and effective. So if I want to have a data removed within 1 month, the controller should do it and should do whatever is possible and needed to address my request. Problem is that just as it happened under the previous directive, controllers are, to say the least, reluctant to comply, especially big companies, especially companies that are acting behind the walls. So, data brokers or like huge companies that have a lot of interest in reducing the amount of control data subjects can have over their data. And the perfect example, and I know you have discussed this, is the ad tech. Now, we all know that as we move around on the internet, but also in the real world, we are being continually tracked and profiled. the official idea is that this is all for targeted advertising, but actually we also know that it's not always the case, because as I mentioned, these data acquired through cookies or other identifiers can be used for other purposes. So not only targeted advertising, can be used for job selection, can be used for political micro-targeting, for assessing researchers and know what they are doing or not, and possibly grant them a funding or not. So it all started with targeted advertising, but then it evolved into something larger, bigger, and shadowy. And so it's definitely a problematic area. Now, this ad tech system is joined by many actors. They collect data about us from a variety of places, including web browsing, connected devices, smart TVs, computers. When we're using a tool or a software to control or to measure some sort of like our research, that in general, a part of this data is also sent out or shared with the software developer, that in turn can also share it with other companies. And so the thing is, given this complex structure, more of these companies, more of these actors are placed in somewhere outside Europe. They are very knowledgeable about us, but very far away. In theory, the GDPR applies to them, because it also applies to non-EU-based companies that are somehow targeting or profiling European-based people. But it's very difficult to control personal data in this field. Is a problematic experience. Some examples, and these examples are somehow going to be discussed in the context of our enforcement projects. Sometimes controllers deviate from user consent, let's say forcing them to accept contracts, or it make it look like users are consenting while in fact they are not. Or sometimes trackers are buried in software we use, or writing document writing software or operating systems. And oftentimes these trackers are neither authorized nor announced. And also data is used in the context of complex and often obscure algorithmic decision-making. And so this is a problem. So we have a problem in terms of information and control asymmetry, because these actors, the ad tech ecosystem, and for whatever purposes they are actually pursuing, they know a lot about us, and we have, at least prima facie, we struggle at controlling them, and to kind of have our data or this processing under a controllable situation. So there is it's a structural problem. And the solution, or at least part of it, is not only legal but also organizational. And this is exactly what we do with Noib. We have a provision that somehow helps us doing what we do. The underlying idea is that structural problems need structural solutions. And so under Article 80, paragraph 1 of the GDPR, not-for-profit bodies can, that are properly constituted in accordance with EU law and active in the field of data protection and of data subject rights and freedoms, they can lodge complaints on behalf of users. They can exercise the rights of, damages on behalf of users. We can represent a multitude of individuals that want to maybe gather up and bring a case to court, or start a class action, for example. And so the idea is to kind of put people together to fight together, to share the risks of legal actions and against a structural problem. That's the one, and that's essentially what we do. And now going to the enforcement projects. This is one of our latest successes. So again, the first issue, we just mentioned it, is, for example, using contract instead of consent to process data for profiling and advertising purposes. When the GDPR came into force, companies were somehow worried that the increased requirements for consent would make this exercise kind of problematic to obtain consent. And so, for example, Meta, they switched from consent to contract, and they said, like, if you want to join Facebook, for example, I'm providing you with this service, but as a part of this service, I am tracking whatever you're doing on my platform because I just need it to perform the contract, which is clearly not true, because in a way it's clear that processing data for advertising purposes and profiling my private life and my private aspects is not necessary to run a social network. But there was this choice, and just after the GDPR was brought into force, we filed several complaints in Austria. Then the complaints moved to Ireland, where Facebook is established. There is this cooperation mechanism in Europe. And yeah, the DPC, which is the Data Protection Commissioner, the Data Protection Authority in Ireland, was very slow. And the first draft was providing for a really low fine, and all the other DPAs in Europe disagreed with the Irish. And the EDPB, which is the European Data Protection Board, overturned the entire decision, imposing a much harder approach and a much higher fine to Meta. And in January and February, both all Meta companies, Instagram, Facebook, WhatsApp, were fined for several hundred million euros. But it was a success. So now they are they're trying to change the legal basis. Probably now they want to switch to legitimate interests, but also legitimate interests are not going to be okay for that sort of processing. But the thing is, that was a success, but the fine, for example, was really not dissuasive, because if you look at the annual turnover of Meta, it's very high. Like, this is just a little scratch on their financial possibilities. Okay, so this is an example, of how you can use the GDPR to kind of fight a structural violation, and possibly after, in a very slow fashion, and pace, but after 4 or 5 years, obtaining some results. The second one is one of our most recent projects. It's about the idea of giving the user the impression of consenting, but actually they are not really consenting, and that's our cookie banners dark patterns project. We know that the ad tech ecosystem is based on online tracking, the user tracking. We know that trackers are essential to the trackers are essential to the industry. The industry needs cookies desperately because otherwise you cannot track people. But the thing is, under Article 5.3 of the Privacy Directive, that provision we mentioned, in order to install cookies, you have to provide a consent. Now, the solution from the industry was that to basically, present an idea, a possibility of choice. So I think all of you have bumped into these cookie banners where you could only accept the cookies and not reject them, for example. Now, obviously, for us that, or maybe having different colors, like having like a big green button with yes, I accept all, and then a small tiny red button with where you're saying no, I reject. And so all these tricks are actually psychological tricks, like performed, built, and drawn to just nudge the user into consenting. But if consent must be, freely given, specific, informed, and unambiguous, can we really say it's valid? Now that we know how the ad tech works, that there is all this huge information exchange, that different actors can use the data I've given. I don't know, because I'm browsing the website of my political party. I don't want, and I don't know if this data is being used by, I don't know, a data broker to select me for a job position, right? And so all these elements are part of the discussion on whether or not the consent we are providing on cookie banners, especially when cookie banners are developed and programmed in that particular shape or with those particular tricks, is valid. And our NOI position is hardly so. We don't think it's valid. So we kind of decided to take action. Obviously, we received literally hundreds, if not thousands, of requests from our users and people we were talking to. Guys, they were asking us, like, guys, please do something against our patterns. It's horrible. I cannot access this website, and I only, I'm allowed to just accept cookies. That's too much. Please do something. And then we were like, okay, let's try. And so we developed a tool. We called it Ispettore, and it's so basically this software scanned the web. And for CMP settings, CMPs are consent management platforms. Basically, it's the tool behind a cookie banner. And sometimes the settings of these tools, so for example, whether the reject all button is available or not, or whether it's put in a small like reddish color instead of being green, you can take it from the HTML code. And so, this software kind of crawled the web or the target websites, more or less, website mostly visited in a member state, or websites dealing with particular categories of data, political affiliations, philosophical or health data, this sort of stuff. And we made a list of websites using these dark patterns. And then we sent them a sort of cease and desist letter that they could comply with the GDPR. And in case they wouldn't, we anticipated the filing of different complaints. We filed already different complaints, and we already won some of them. We already also got a European Data Protection Board task force that recently clarified what constitute dark patterns and what not. And companies are slowly but steadily improving the quality of cookie banners. I don't know if we noticed that there was what we call it a sort of spillover effect. So even companies that were not directly targeted with our complaints, because of it, they also contacted us, they kind of complied with to kind of obtain a proper consent. After these actions were brought, we noticed that some reject buttons were finally showing up in different cookie banners of important websites. So that's again a way to reduce the tracking. Because once users are given the possibility of rejecting cookies, then you are necessarily reducing the quantity of cookies and trackers available in the system, and you're kind of cutting the provision of information to data brokers by getting rid of the trackers themselves. It's not the final, a conclusive solution, but it's a part of it. And so that is another example. Then we also did something on the enforcement projects, and the idea, again, trackers are key to the system, but trackers are not only cookies, but also mobile identifiers generated by operating systems or the software we are using. These trackers are generally automatically installed. They are oftentimes not announced in the privacy policies, whether there is one or not. They are accessed by operating system or software developers and third parties for whatever they want to do. So we have the same problem that we got with cookies, but just in a different within a different technical infrastructure, which is the mobile environment. But it can also, the same goes with like smart TVs, with computers and all that. So we must be aware, and we will just probably talk a little bit more about this tomorrow. We must be aware that like these elements, these trackers are buried in our computers, in our in the software we're using to do our research, so there is a risk that what we're doing is somehow tracked or known in advance. So these cookies, they look like a cookie, smell like a cookie, works like a cookie. So probably it is a cookie. And so we kind of envisage this possibility of going after these mobile identifiers or these mobile trackers by using Article 5.3 of the e-privacy directive, which is again like technologically neutral. So it's known as cookie law, but it also applies to other types of trackers. And we filed several complaints. We are going to file more in the near future. Germany, France, Spain. Some of them have been rejected, unfortunately. Some are waiting for results, but that is because, unfortunately, the e-privacy directive does not apply directly to each member state, and sometimes the transposition is, was like given to the states. So there is some problems in terms of like protecting ourselves from these trackers themselves. And the European institutions have been discussing like a new e-privacy regulation, so like a law that would apply directly for, I think, 5 or 6 years, and nothing, probably even more, but nothing has yet been adopted. So we are a little bit, moving in the dark in that field. And then like another project that we recently filed is this authentication problem. So generally, if you want to exercise your right, let's say access, erasure, objection, you have to prove your identity to the controller. You have to authenticate with the controller. And classical example, in 2015, you sign like a contract, like to rent your flat, and then you get married, whatever, and you change your surname. And you want to have that data rectified at the controller's database. So you go there, or generally you go there with your identity card, or you send it by mail, and you are like, yeah, this is my new surname, please correct it. And that's how it worked in a sort of non-digital environment, and that made sense. The problem with ad tech is that this is hardly possible because, well, we know that the data brokers really and precisely know our identities, but at the same time, they don't really have yet, or possibly, hopefully not, a copy of my ID card. So how can I possibly authenticate with them if my ID card is useless in that sense? There are ways. One is, to kind of use the cookie or the mobile identifier itself. These are unique values. So this is my identity in the environment. But the problem is that in the practical experience, controllers are, basically they try to make the authentication very difficult, and they put considerable obstacles in the way of exercising our GDPR rights. For example, they sometimes require data subjects to provide additional details, such as where you live, or where you have lived for the last 12 years. That was already like one case that I bumped into, or maybe filling out like written paper form and provide it with a signature, which by the way is biometric data, or maybe to send them your passport. And the thing is, you don't want to do it, because data subject rights must be facilitated, and the authentication must always happen like in a sort of minimized way, right? So if you're starting a processing with a cookie and you are controlling a lot of the information that I'm generating online, then that cookie should be the only option for you to authenticate me. Or other ways, there are possibilities to safely authenticate people with cookies. That's exactly what the EDPB, which is this European Data Protection Board, suggested in a recent guidelines on access. Basically, if you want to exercise your rights towards a data broker, you should just put the copy of the cookies it has dropped into your device, and that is your identification element, so that you can get into their fully exercise your GDPR rights. But controllers, obviously, it's not only the EDPB, it was also like the widespread case law available in Europe. It's popping up everywhere. And because we kind of share that view, we file different complaints against data brokers based in not in the EU, so the most distant, but also the most powerful. And we file different complaints at different data protection authorities, and we are waiting for an answer. And then finally, the last thing, it's about workplace surveillance. We and I recently worked with Uniglobal, which is a federation of unions and different work councils, union councils at national level, Germany, UK, Italy, Slovakia, and Poland, to basically use the GDPR to protect workers from invasive workplace surveillance. And Amazon was an example that of this surveillance. We told workers what rights they had. In this case, was a right of access, and we drafted some access requests for them, and they submitted it to the company. The main points of these requests were, well, to be informed about the recipients, and the sources of data. Whether there was any sort of background check running about workers, what type of surveillance had been undertaken at the workplace, CCTV cameras, but also tracking the use of scanners for these workers working, these employees working at the warehouses, or those driving. They are kind of required to wear some tools so that the company can track the efficiency and effectiveness of their action and during the work shifts. And well, we just filed different access requests. We got an answer from the company, which we found unfortunately incomplete. So we just very recently replied inviting the company to comply with the GDPR and provide full information. So let's see what happens. But in case the response shall stay insufficient, incomplete, I've already been told by workers that they may want to go to court. So let's see what happens. In that case, the point was basically we are trying to use the access requests to shed some light over automated decision making and data sharing within this company. That's it. And the last thing is the problem of enforcement. So we have talked about going to court. We've talked about filing complaints at the DPAs, but especially when the cases end up in jurisdictions where these companies are established, it's very difficult to progress and to obtain a response in a timely manner. Even though the European Charter of Fundamental Rights tells that we are entitled to get a decision in a reasonable time, that the process of the investigation and in general the decision-making process by the authorities must be transparent, must be accountable. It's very difficult. Authorities oppose all sorts of secrets and slowness in dealing with these complaints. And let's say, for example, in 2019, we filed different complaints against some of these streaming companies that we were mentioning before because of lack of response again to access requests. And it took them 4 years to just, I think we filed 11 complaints or 12, and we just only got one decision. And for the others, decisions are just very slowly coming. So this is not optimal, obviously, because if I want to obtain a decision, it should come very quickly, especially if the case is not so difficult as this is the case. They are not difficult stuff. So we have also kind of brought the DPA's inertia inactivity to court, and we have already won some cases. So basically, after 3-4 years, when we realized that things were not moving up, we just filed an action against the DPAs, let's say in Sweden, for example. And I was very surprised, but we got a decision after, I think, 3 or 4 months, forcing the authorities to decide. So the idea is that we to kind of complete the discussion is to kind of file our complaints. And then when it takes too long and this slowness is affecting the very nature of these GDPR rights, then we also go to court and to kind of reduce the risk of arbitrariness by the authorities. So that's mostly it. As I mentioned before, we also have this GDPR Hub and GDPR Today project. So we summarize decisions from throughout Europe, from different languages to English. So if you want, you can always subscribe to this newsletter. I'm the curator of this work. So I'm always very happy to, have new subscribers and also feedback on how you feel and how you like it. We also have a secure drop system for whistleblowers. One of the major issues here is we seldom do not know whether what's really happening, and sometimes we receive tips from the inside of the industry, and that is obviously very, very important. It's a secure way to let us know what's going on and what can be done. In general, you can always contact me at sr@noib.eu and on our website. You can always call us. So I think I'm done. Thank you.
Thank you so much, Stefano. So much valuable material. Thank you. Please raise your hands and let's start the discussion. Questions, comments, if any. Giuseppe Ballocchi, please go ahead. Unmute. Thank you.
Yes, thank you so much for your very rich presentation and content. And I would like to ask you concerning the data minimization principle of GDPR, which, as far as I understand it, as I read it, data should be adequate, relevant, and limited to what is necessary. But it seems to me that in situations other than also not only online, but for instance, in financial services, very often you are asked from banks, for instance, by banks, data that is completely irrelevant or actually not needed. For instance, routinely, many banks to open an account ask for income tax declaration, which arguably is not really needed because they don't, as long as they are sure that you are not a money launderer, they don't need to know the totality of one's business. So what is the recourse? Can you have a recourse under GDPR for such things or not?
Thanks, Giuseppe, for your question. Definitely, yes, you do have a remedy because this is a violation of the data minimization principle, as you just mentioned. There is the only way I can foresee for them to kind of put a defense would be to kind of say that they are doing it in the execution of some legal obligation. Now, the next thing in that case, should that be the case, one should, before filing any complaint, one should check, first of all, whether that legal obligation is really applicable to that bank. And second, what it actually says. Because let's say, even if there is this interesting part and some decisions already around this bank tendency of accumulating data and doing it in view of a legal obligation. And so I think it was a Finnish decision recently. They kind of said, yeah, there was a legal obligation, but actually it doesn't really say that you have to collect all this data. So if the bank is executing the legal obligation excessively, you have a legal remedy, but also not directly, unfortunately, at the DPA, but before a court. Let's say the bank, the legal obligation itself requires the controller to obtain information that is not needed. Then you could theoretically, file a sort of constitutional remedy against that law itself, because in breach of the GDPR.
Yeah, no, sorry if I can comment on that, because sometimes, the problem is that under the false cover of a legal obligation, which is very, very broadly interpreted, well above the intention of the law, very valuable commercial data is collected and used for other purposes, like in this case, to propose products and other things. But thank you very much for your answer. Thank you.
No, thank you. And that's absolutely the case. And that's the whole logic of this ad tech ecosystem. If you probably tomorrow, I can bring some images from data brokers that they claim of having detailed mapping and about some data subjects at fiscal tax position. So how can a data broker can possibly have that information if not by having gotten it somewhere else, probably a bank or anyone else who had asked for it previously. So yeah, it's a part of the problem, and that's what we're trying to kind of fix. Thanks.
Thank you. Thank you both. Very useful, because it happens in many countries, from many banks. I also have this problem. Roman, please unmute.
Hello, can you hear me?
Yes.
Okay, Stefano, firstly, thanks for the presentation and being here. It's a comment/question. So I signed up with on a website of a pretty big company, which should remain unnamed, at least for this recording. And so while signing up, I signed up using email. I had to provide some of my personal data, which they needed. So my first name, last name, bunch of other stuff. And sometime later, I don't need this account anymore. So I emailed their compliance department asking to delete all the information they have, which is tied to like this email that I'm emailing them from and this account. In response, they replied with a pretty long text asking me to provide a copy of my IDs to verify that I am who I am. And this doesn't make sense because when I signed up, I didn't need to verify myself using an ID. So in fact, they don't even have a way to check if I entered my first name and last name correctly. So only verification bridge between this information and me is this exact email address that I currently emailing them from. So I replied explaining like my points of view, because honestly, I would rather just change my personal data on my accounts on their website and leave it as it is, rather than send them a copy of my IDs, which will probably remain in the inbox of their departments forever until on their servers. And they replied again that they need to verify my name because they need to protect the private. Like, I don't know, like their explanation was long again, but it didn't make much sense to me. And I'm still in the correspondence with them arguing. But if you have an advice, or if you have a magical sentence due to all your practice and experience that I could use in my email to kind of force them to do something, I would really appreciate that.
No, look, I have just one question. So the email that you used to create the account is the same one you are using to exercise your right? Is that correct?
Exactly.
Yeah.
Yes.
Then no. Like what they're doing is, it's typical stuff they generally do, and this requiring ID cards when the processing didn't start with ID cards. It's wrong. You have like definitely you can check on the EDPB guidelines on the right of access to access. They've been adopted like 2 weeks ago, finally in their final version, and it's quite clear. You will find like literally the paragraph where they say that requiring an ID card in case of exercise of rights, that could be not only access but also deletion, should not be doable unless strictly necessary. And really, for them to prove that this requirement is strictly necessary, it's hardly doable. So just probably you could just tell them, like I already asked you to delete my account. You have a burden to like a obligation to facilitate my request. Processing didn't start with an ID card, and so just do it. You can send me. What they can do is that to verify your email, they can send you like a link, like a sort of authentication link, and have that unique connection between your email and the one that has generated the account. That's it. Otherwise, you can just go to court or file a free complaint at the Data Protection Authority. It's free. And yeah, you can also send me an email in case you want to some further help. Okay.
Okay.
That's
Thanks
fantastic.
for your yeah.
Sure.
Fantastic. I have a whole page of questions, but I will leave them for tomorrow because people are probably starting to be hungry, and we are lucky to have you again, Stefano, tomorrow. But just to summarize, after Roman's fantastic example that happens potentially to all of us, you are saying that NOIB works on donations, but people can write to NOIB to ask for help when they want to go to court.
Mm-hmm.
And you protect them free of charge thanks to the donations. How does this work actually?
Yeah,
because I heard we talked about to summarize all the acronyms I've written down. We talked about none of your business, NOIB. We talked about EDRI, the European Digital Rights Initiative. We talked about EDPB, the European Data Protection Board. And so I would like to ask, who should one write to ask for help with least expense?
So that's the thing. So we are running on funding by members. So like whenever you are our member, what we can do always is to kind of provide some advice in terms of like, sort of 1 or 2 hours consultation in case you have a trouble. That is always possible. Then in case there is a case, like a problem, we had this internal system, and we obviously, because our resources are limited, it's not that we represent all our members. It's not possible. That would be literally, we just, if we see that there's I don't know, that 100 members mentioning a problem, then, we consider the possibility of taking action, because maybe it's a structural issue. And we may end up representing some of them. In other occasions, they are just telling us, hey guys, can you do something on that? And then maybe there is another data subject popping up. So it's rather flexible in that sense. So the consultancy to members is always possible. And then we also have like the actions, both data protection authorities or courts. But that goes with the priorities and also assessment. If we think we will win the case, if we think we don't, if we think we have evidence, it's a mix of factors that we consider.
Thank you.
Sure.
I think the best is, if there are no other raised hands now, to look forward to tomorrow. It's wonderful that you are available again. And say goodbye and thank you very much for now.
Sure. Thank you. Thanks a lot. And I'll see you tomorrow.
Okay. Bye.
Ciao. Bye.